What's up everyone, it's the Law School Lumberjack. I hope you're having a wonderful day. Today we're going to be doing another installment of our Contracts Law 101 series, and today we will be going through the equitable doctrine of rectification. So let's say you're on a law school exam and you see a fact pattern wherein two people make a verbal agreement and then later on the written agreement or the written contract doesn't conform to that previous verbal agreement. In that case, you can have two main options. You can discuss the doctrine of mistake, which we will go through in a future video, or you can proceed with the equitable doctrine of rectification, which we'll be going through today. As rectification is a fairly discrete equitable remedy, this video will be a fairly short one. So rectification is essentially an equitable doctrine that allows the court to order that a portion of the contract, usually a clause or certain wording within a contract, be rewritten to conform to a previous verbal agreement. One of the leading cases on contractual rectification in Canada is the case of Sylvan Lake and Performance Industries. So the facts of the Sylvan Lake case are as such. The proprietor of Sylvan Lake Golf Course and the proprietor of Performance Industries enter into a joint venture with respect to the Sylvan Lake Golf Course. As part of this joint venture, the owner of Sylvan Lake Golf Course wants a portion of land which is 480 yards by 110 yards on the 18th hole in order for him to develop two or double row houses. By way of a verbal agreement, the proprietor of Performance Industries agrees that this is acceptable. The lawyer for the companies drafted the joint venture agreement. However, by inadvertence, instead of the plot of land being 480 yards by 110 yards, which is what it's supposed to be, it's written as 480 yards by 110 feet. What this essentially means is that the proprietor of the Sylvan Lake Golf Course cannot make double row houses, they can only make one row of houses. Both parties sign this agreement. The proprietor of Sylvan Lake allegedly signs this agreement without reading the contract. It later becomes apparent to that proprietor that the contract reads 110 feet rather than 110 yards. Obviously, the proprietor of Sylvan Lake Golf Course takes issue with this. However, the owner of Performance Industries refuses to amend the contract by agreement. The owner of Performance Industries sues for specific performance to enforce the contract. Conversely, the owner of Sylvan Lake then countersues for rectification. So what we're not going to focus on the specific performance case. We're going to be focusing on the case surrounding rectification brought by the owner of Sylvan Lake. This goes through the Alberta Court of Queen's Bench, to the Alberta Court of Appeal, and finally to the Supreme Court of Canada. All three courts agree that this is a case where rectification should be ordered. Now, the reason why the Supreme Court of Canada's decision is so important is it sets out the FourPart Test for determining whether or not rectification should be ordered or granted by the court. So the FourPart Test, or in other words, what the plaintiff or the person who's seeking to have the contract rectified or changed has to prove is as such. Firstly, the plaintiff must not only prove that there was a verbal agreement between the plaintiff and defendant, but also the content of that agreement. So the plaintiff has to put before the court evidence of the terms of that verbal agreement. Secondly, and arguably most importantly, the plaintiff has to show not only that there was some discrepancy between that verbal agreement and the final written agreement that was executed between the parties, but also the plaintiff has to show that the defendant knew or ought to have known about this discrepancy. The court in Sylvan Lake holds it as a general rule. It will only be in situations where the defendant's reliance on the written contract in the face of the verbal contract amounts to the equivalent of fraud that the court will step in and protect the plaintiff by rectifying the written contract to conform with the terms of the verbal agreement. Now, in this case, what the court, by saying fraud, is referring to is equitable or constructive fraud. What they're essentially saying is if it would be truly unconscionable for the defendant to rely on the written agreement in the face of the verbal agreement, it may be in the interest of justice for the court to step in and rectify the contract. Thirdly, once the plaintiff proves those two threshold issues, the plaintiff has to prove the precise form of the written agreement that takes into account the verbal agreement. So essentially what has to happen is the plaintiff has to show what changes need to be made to the written agreement to conform with the verbal agreement. And fourthly, and quite importantly, in order to meet the previous three parts of that test, the plaintiff must prove the three foregoing parts by proof which is beyond a fair and reasonable doubt. Now, What in practice this essentially becomes is it's actually a greater burden than the balance of probabilities we see in a regular civil case, but it doesn't quite reach the level of beyond a reasonable doubt that we would see in a criminal law case. So in essence, it's somewhere between these two burdens, likely somewhere in the middle, that the plaintiff has to prove the three foregoing parts. But essentially the most important thing to remember as someone who's writing a law school exam is that the plaintiff has a higher burden or a heightened threshold compared to what they would normally face in a civil claim. So obviously the court sides with the plaintiff, but in coming to their decision, they do create a bit of a caveat for the four-part test. So the court recognizes that by failing to do their due diligence or by negligently failing to read the contract, the plaintiff has in fact placed some fault on itself. So the court does hold that if by ordering rectification, the defendant would face undue liability or undue prejudice as a result of that equitable doctrine, the court has discretion to decide against ordering rectification. So essentially what this amounts to is a weighing of the fault and a weighing of the prejudices and liabilities between the two parties to determine whether or not rectification should be ordered. There are a couple other caveats that the court explains which could prevent rectification from being ordered or could mean that the plaintiff doesn't have standing to ask for rectification. The first one being inordinate delay. So the plaintiff cannot sit on their rights for too long before asking for rectification. If a plaintiff sits on their rights and delays for an inordinate period of time, they are arguably coming to the court with unclean hands. Remember that this is an equitable remedy, so if a party comes to the court with unclean hands and asks for an equitable remedy, the court has the discretion and the ability to refuse that equitable remedy. So if a plaintiff is delaying or causing what's called laches and then asks for rectification, the court can hold that that is improper given the delay. Finally, if there is an innocent third party involved in this transaction, wherein rectification would harm that third party, the court is much less likely to order rectification as that third party who has no fault at all will be prejudiced. In summary, if you're in a law school exam, you see a verbal agreement between two parties and a written agreement which differs from that, it may make sense for you to bring up the doctrine of rectification. I hope this video was helpful. If it was, I really appreciate it if you could like and subscribe. Thank you very much. Take care. Have a good evening.